There are moments in a case that feel like they should bring closure. A verdict is read, a sentence is handed down, the courtroom empties, and the world moves on. But for the families at the center of this story, for the community of Frisco, Texas, and for the millions of people who followed every single development of this case over the past 14 months, closure has not arrived. It may never fully arrive. Because what happened on April 2, 2025, at a high school track meet in a Dallas suburb, did not end when a jury spoke its verdict on June 9, 2026. It simply entered a new chapter, one that is quieter, more bureaucratic, and in some ways even more difficult to sit with than the trial itself. This is the story of what comes after. What happens when the cameras leave the courthouse steps. What the system looks like from the inside when a 19-year-old walks through the gates of a Texas state prison. And what questions this case, one that became a flashpoint for conversations about race, justice, self-defense, and the future of young people in America, continues to leave unanswered even now. Before we go further, if you are new to the verdict room, this channel exists to do one thing: follow the evidence wherever it leads and deliver a real conclusion. We do not leave you hanging. We do not trade in speculation without saying so. Subscribe right now and hit the notification bell, because every week we go deeper into the cases that deserve more than a headline. Now let's talk about what is actually happening with Karmelo Anthony today. To understand where things stand right now, you have to go back to where it all started. Not the arrest, not the trial, the day itself. April 2nd, 2025 was a Wednesday morning in Frisco, Texas. The kind of morning that starts ordinary and ends with everyone who was there trying to make sense of what they witnessed. There was a regional high school track and field championship being held at David Kuykendall Stadium on the campus of Memorial High School. Hundreds of young athletes, coaches, parents watching from the bleachers. A spring morning in North Texas that should have been just another competition day on the calendar. Then the storms came in. When rain delays hit outdoor track meets, everyone scrambles for shelter. Pop-up tents that teams bring to the venue fill up fast. Athletes from different schools end up near each other in ways that would not happen under normal circumstances. And in that compressed, wet, chaotic environment, something started between two 17-year-olds who had never met before that day. Karmelo Anthony was a student at Centennial High School, also in Frisco. He was captain of both the track team and the football team there. By all accounts that emerged during the investigation and trial, he was a young man with no prior criminal history, who held down 2 part-time jobs and was weeks away from graduating. He had never had a brush with the law before. Austin Metcalf attended Memorial High School, the school hosting the meet that day. He was a junior, an MVP linebacker on the football team. He had a twin brother named Hunter who competed alongside him. Austin was, by every description from people who knew him, an athlete who worked hard and carried himself with the kind of physical confidence that comes from years of competitive sports. He weighed somewhere between 50 and 60 pounds more than Anthony. These two young men did not know each other. There was no prior grudge, no history, nothing that would suggest on the morning of April 2nd that their lives would collide in a way that could never be undone. What happened under that tent became the central question of a trial that gripped the country. According to testimony from multiple witnesses who were present, Anthony had entered Memorial High School's team tent to get out of the rain. Austin's twin brother Hunter told him to leave. Then Austin himself engaged with Anthony directly. The exchange escalated. Witnesses recalled Anthony saying words to the effect of, "Touch me and see what happens," while keeping his hands inside his backpack. The accounts of exactly what happened next were disputed throughout the trial. Prosecutors argued that Austin Metcalf pushed Anthony and that Anthony then pulled a concealed knife from that backpack and stabbed Austin once in the chest. One stab wound. That was all it took. Austin ran from the tent, grabbing at his chest, calling out for help. By the time first responders reached him, he was not conscious and was not breathing. Emergency personnel performed chest compressions at the scene. He was transported to a hospital and pronounced dead shortly after arriving. He was 17 years old. He had a life ahead of him, a college career that people around him believed was coming, a brother who would later accept his diploma on his behalf at graduation because Austin was not there to walk across the stage himself. When officers detained Karmelo Anthony at the scene, he was emotional. He was crying. He reportedly asked whether Austin was going to be all right. He told officers he had been protecting himself. And in a statement that prosecutors would later use at trial, he reportedly said, when told he was under arrest, something to the effect of, "I'm not alleged, I did it." Those words followed Anthony through every stage of the legal process that came after. He was charged with murder and transported to the Collin County Jail. Because of his age, 17 at the time of the incident, there were early questions about how the case would proceed. But under Texas law, defendants who are 17 or older at the time of a crime are prosecuted as adults. Anthony entered the adult criminal justice system. In April of 2025, a judge lowered his bond from $1 million to $250,000. Anthony was released. His conditions were strict. He had to be supervised by an adult at all times, check in with the court weekly, and stay completely off social media. He was also prohibited from contacting Austin Metcalf's family. A grand jury indicted him in June 2025. And then came months of pretrial proceedings, legal maneuvering, and public tension that never really let up. The racial dimension of this case was impossible to separate from the conversation that built around it. Austin Metcalf was white. Karmelo Anthony is black. In the current climate of American public discourse, that combination, a black teenager charged with killing a white teenager, became a lens through which millions of people processed the entire story, often without any connection to the actual facts. White nationalist groups showed up to protest at the stadium where Austin died. Online fundraisers exploded. The Metcalf family had to deal with people using their son's death as a symbol for causes he never represented. Anthony's family faced death threats that were serious enough that the courts approved him moving to an undisclosed location for his own safety. Both fathers were eventually forced to leave their jobs because of harassment. The judge who lowered the bond was doxxed and received threats. The FBI became involved. Austin Metcalf's father, to his enormous credit, personally pushed back against the groups trying to weaponize his son's death. He told protest organizers directly that their efforts to deepen racial division were not welcome and that they did not speak for his family. That took something. A man in the middle of the worst grief imaginable, who still found the presence of mind to say, "This is not what my son would have wanted attached to his name." Meanwhile, the fundraising on Anthony's behalf reached over $500,000. That money became its own controversy when rumors spread online that the family had used it to buy a car and a nearly $1 million home. Those claims were investigated and debunked. But the damage was done in certain corners of the internet, and the misinformation spread faster than any correction could follow. This was the atmosphere surrounding one of the most closely watched trials in Texas in recent memory. Jury selection began on June 1, 2026. With a jury pool of nearly 600 people, the process took days. The defense raised a Batson challenge during selection. This is a legal mechanism that allows attorneys to challenge the removal of jurors on racial grounds. The prosecution had struck 3 black female jurors from the pool. The defense argued those women were similarly situated to a white female juror who was not removed. Prosecutors responded that the strikes were made for race-neutral reasons, specifically that the 3 women were teachers of school-aged children. Judge John Roach ruled in favor of the prosecution and allowed the strikes. The jury that was ultimately seated included no black jurors, though it was not an all-white panel. Several jurors were people of color, and the group included 11 women and 7 men, counting alternates. That composition became a focal point for commentary and criticism throughout the trial and afterward. Opening statements came on June 4th. The Collin County District Attorney argued that Anthony had provoked the confrontation, brought a concealed knife into a public school event, and then used it in what prosecutors called a sneak attack. The word that the prosecution kept returning to throughout the trial was unjustified. They acknowledged there had been a push. They argued that a push did not justify a knife. The defense told a different story. They described a scene where Anthony was already seated when he was confronted by Austin and his brother together. That he was outnumbered and outsized. That he was being told to leave a space with no safe exit. That in a split second of fear, surrounded by people he did not know, with someone physically larger initiating contact, he reacted in the only way his body told him was available. Witness testimony spanned multiple days. Some students said they saw Austin push Anthony before the stabbing. One witness said Anthony had been asked to leave as many as 15 times and kept his hands in his backpack during the entire exchange. The defense tried to establish that Anthony was the smaller, more vulnerable party in the confrontation. Prosecutors emphasized that Anthony had made a verbal threat before any physical contact, that he had a weapon ready, and that he was not facing the kind of danger that Texas law recognizes as sufficient to justify deadly force. A key legal threshold in Texas self-defense law is this: to use deadly force, a person must reasonably believe that such force is immediately necessary to protect against death or serious bodily injury. Whether a single push by a larger person in a crowded environment clears that bar was ultimately the question the jury had to answer. They deliberated for 3 hours. On June 9, 2026, at 1:35 in the afternoon, the jury returned a verdict of guilty of murder. They rejected the self-defense claim. They also rejected what is called a sudden passion argument, a legal standard in Texas that can reduce a murder conviction to a lower charge if the defendant can show they acted under an immediate emotional provocation that any ordinary person might respond to in the same way. The jury did not accept that framing. They sentenced Karmelo Anthony to 35 years in prison. In a courtroom that had been surrounded for days by supporters of both families, protesters, far-right activists, and journalists from across the country, that number landed differently depending on which side of the street you were standing on. For the Metcalf family, it represented accountability. For Anthony's supporters, it represented something else entirely. A question about whether the sentence was proportionate to a moment that lasted seconds, made by a teenager, in a chaotic environment nobody planned. The day after sentencing, Karmelo Anthony was transferred from local custody into the Texas Department of Criminal Justice System. He was 19 years old, and the world he entered on June 10, 2026, is as different from a high school track meet as anything you can imagine. The first thing to understand about the Texas prison intake process is that it is not what television makes it look like. There is no immediate placement into a permanent cell block. There is no dramatic confrontation with the general population on day one. The initial phase is intensely bureaucratic. It is about classification, documentation, and evaluation. Who are you? What is your medical status? What are your mental health needs? What security level does the system assign to you based on the crime you committed, the sentence you received, and the behavioral risk profile the state builds around you? Personal clothing is taken. State-issued uniforms replace it. A TDCJ identification number is assigned. From that moment forward, you are no longer a defendant awaiting trial. You are a convicted inmate serving a sentence. The institution now controls your schedule, your meals, your movement, your communications, your access to medical care, and the rhythm of every single day. Anthony was initially transferred to the Wallace PAC unit in Navasota, Texas, a facility in Grimes County, about an hour northwest of Houston. This is consistent with the early intake process for the TDCJ, where new arrivals go through diagnostic assessment before permanent housing assignments are made. The state conducts health screenings, both physical and mental. It reviews educational background. It evaluates safety concerns, including whether an inmate may be at elevated risk of victimization or conflict within the general population. For a high-profile case like this, one that generated national media attention, death threats, and deep community fractures, those safety assessments are not routine checkboxes. They carry real weight. Security classification in the Texas prison system is a detailed process. It accounts for the nature of the offense, the length of the sentence, any prior criminal history, behavior during custody so far, and the age of the inmate. Anthony is 19. He is serving a 35-year sentence for murder involving a deadly weapon. His security profile under the TDCJ's framework will be scrutinized carefully. Higher risk classifications lead to more restricted housing environments. That does not necessarily mean solitary confinement, but it means the state takes the assignment seriously and does not treat a murder conviction lightly when deciding where someone lives inside the system. A typical day in a Texas state prison facility is nothing like life outside. It is dictated entirely by institutional schedules. You wake when the facility says to wake. You eat at times the facility designates. Movement between areas is controlled, monitored, and subject to lockdown at any moment. Recreation exists, but it is supervised, scheduled, and can be suspended at any time due to security issues. Work assignments are made by the institution: kitchen work, laundry, maintenance, agricultural programs, manufacturing. None of it is optional in the way that a job on the outside is optional. For a 19-year-old who, 14 months ago, was captain of his school's track and football teams, working 2 part-time jobs, and weeks away from graduating, the contrast is almost impossible to fully comprehend from the outside. Anthony's family communication with him is now governed entirely by TDCJ rules. Phone calls are permitted but limited in length and monitored. They must go through approved systems and be placed to approved contacts. All calls except those with legal counsel are recorded. Mail goes through a digital processing center where it is scanned before being delivered electronically. Visits are subject to facility scheduling, custody status, and intake restrictions that can delay access for weeks during the early phase of incarceration. For the family of a young person entering this system, the adjustment is jarring in a way that people who have not lived it rarely understand. You cannot just call, you cannot just visit. Every interaction with your son is mediated by an institution that operates on its own calendar and answers to its own priorities. Now let's talk about the numbers, because the 35-year sentence carries a specific legal weight under Texas law that is important to understand. Under Texas sentencing rules, certain serious offenses, including murder involving the use of a deadly weapon, require an inmate to serve 1/2 of the sentence or 30 calendar years, whichever is less, before becoming eligible for parole consideration. On a 35-year sentence, half is 17.5 years, and that means, under current law, Anthony cannot even be reviewed for parole until he has served approximately 17.5 calendar years. And here is the part that is often misunderstood: good conduct time. The reduction in sentence that inmates can accumulate by following rules, participating in programs, and staying out of disciplinary trouble does not shorten the initial parole eligibility window for this category of offense. For assaultive crimes involving deadly weapons in Texas, good conduct time does not accelerate when you first become eligible for parole consideration. What this means in practical terms is that Anthony, who turned 19 in the weeks following his sentencing, will be close to 37 years old before the Texas Board of Pardons and Paroles can even open his file for review. And reaching that eligibility date is not the same as being released. The parole board examines the offense, the behavior record inside the facility, program participation, and victim impact input. Austin Metcalf's family has the right to speak to that board. The severity of a murder conviction makes parole significantly harder to secure on a first review in the Texas system. If parole is denied, which is common in serious violent cases, Anthony waits for the next review cycle and tries again. He could serve the full 35 years. He could serve more if something goes wrong inside the facility. He could, in a best-case scenario, be released in the middle of his 30s, having spent the entirety of his young adult life inside. That is the reality of what June 9, 2026 set in motion. On June 10, 2026, Anthony filed notice of his intention to appeal the conviction. That filing was expected. His legal team had been anticipating an appeal from the moment the verdict was announced. What surprised some observers who had been following the case closely was a separate filing shortly thereafter, a pauper's oath, in which Anthony formally told the court he could not afford to pay for appellate legal representation and was requesting court-appointed counsel. Given that the fundraising campaign on his behalf had reportedly raised over $600,000, some reports placed the figure even higher. This created genuine confusion and a fresh wave of online commentary. How could someone who raised that much money claim inability to afford a lawyer? The answer, for anyone who has watched a complex murder prosecution up close, is less surprising than it might seem. A first-degree murder defense in a high-profile case is extraordinarily expensive. The costs of trial preparation alone, expert witnesses, forensic consultants, the official court record, investigative work, attorney fees across 14 months of active litigation can consume enormous sums. There is also no guarantee that the funds raised online were ever fully accessible or that all of it was directed toward legal costs. The appellate process is a separate and additional financial undertaking from the trial defense. The court will review the pauper's oath and make a determination about whether appointed counsel is warranted. If it is granted, Anthony will receive representation for his appeal at public expense, which is his constitutional right regardless of what has happened in any crowdfunding campaign. The appeal itself is not a new trial. This is a critically important distinction that gets lost in almost every online discussion of cases like this one. An appellate court does not seat a new jury. It does not hear new witnesses or review new evidence. What it does is examine the written record of the original trial. Every motion, every ruling, every moment where an objection was raised or a legal question was decided, and determine whether errors were made that affected the fairness of the proceedings. The most significant ground that Anthony's legal team is expected to argue on appeal centers on the Batson challenge that was raised during jury selection. The defense argued at the time that the prosecution's removal of 3 black female jurors from the pool was racially motivated. The trial court sided with the prosecution, accepting the race-neutral explanation that those jurors were teachers of school-aged children, and that a white juror who was also an educator but not in a traditional school setting was therefore differently situated. An appellate court will review how that ruling was handled. It will look at whether the trial court applied the correct legal standard when evaluating the Batson challenge, and whether the explanation offered was genuinely race-neutral or whether it was a pretext. This is a legitimate legal argument and not a frivolous one. Batson challenges have been the basis of appellate reversals in serious cases across the country. There are other potential grounds as well, though the specific arguments will become clearer once the formal appellate briefs are filed. The rejection of the sudden passion instruction, the admissibility of certain evidence, and the instructions given to the jury are all areas where defense attorneys typically look for grounds to challenge a conviction. But here is something that the appeal conversation must include, because it matters enormously and often goes unsaid in social media discussions. Winning an appeal does not mean freedom. If an appellate court finds that a serious legal error occurred and reverses the conviction, the most common outcome is a new trial, not a dismissal of charges. A new trial, before a new jury, with the same evidence presented again. And in that new trial, the outcome is not predetermined. A new jury could convict again. A new jury could convict and impose a more severe sentence than 35 years, because the new jury is not bound by what the first jury decided. The gamble of an appeal in a case like this is real, and it is something that any defense strategy must weigh seriously. None of this is academic for the families involved. Austin Metcalf's parents buried their son. His twin brother Hunter graduated without him. The family has continued to speak publicly about what they lost, not to sensationalize it, but because they believe the world should understand that Austin was a real person with a future that was taken from him in seconds. His father has been consistent and dignified throughout this entire process, even when groups tried to use Austin's death for purposes his family never endorsed. The Metcalfs have said clearly that the trial was about accountability, about law, and about the reality that a 17-year-old boy died. For them, the 35-year sentence is what the legal system can offer. It does not bring their son back. It does not fill the seat at the graduation ceremony or the chair at the dinner table. But it is the system's answer to what happened under that tent. And they will be part of every parole hearing that comes, reminding a board of what was taken. For Anthony's family, this is a different kind of devastation. Their son, by every account, had a future too. 2 part-time jobs, team captain, on track to graduate, no prior record. And now he is 19 years old and in state custody, with a sentence that will keep him there until deep into his adult life, assuming everything goes as the system intends. They believe the confrontation was more complicated than the verdict acknowledges. They are grieving the loss of their son's freedom even as they try to hold him close through limited phone calls and scheduled visits. And they are navigating an appeal process that could take years and carries its own enormous risks. Both of these truths exist at the same time. They do not cancel each other out. There are legitimate questions that this case puts in front of everyone who has followed it, and those questions do not disappear when sentencing ends. What does proportionality look like when a physical confrontation between 2 teenagers, one armed, one not, produces a result that sends one of them to prison for decades? Texas law required the jury to measure Anthony's response against the specific standard of an immediate threat of death or serious bodily injury. The jury, after hearing all of the evidence, determined that standard was not met. But the fact that the jury had the power to consider sudden passion, a reduced charge that acknowledges that human beings sometimes respond to provocation in ways that are not fully rational, and rejected it, tells you something about how they read the testimony. What does the Batson Challenge tell us about where jury selection law stands today? The standard for proving a Batson violation is genuinely difficult to meet, and trial judges have significant discretion in evaluating the race-neutral explanations offered by prosecutors. Critics of that framework argue it gives prosecutors cover for racially motivated strikes. Defenders of the current system argue that without an explicit admission of racial motivation, courts cannot simply assume bad faith. The Anthony appeal may give a higher court an opportunity to say something about how lower courts should scrutinize those explanations. And what does this case say about the world that young people in Frisco, Texas, and across the country are navigating every single day? A rain delay, a crowded tent, two teenagers who did not know each other, moments of tension that escalated faster than anyone could process, one dead, one in prison for the better part of his life, families shattered in different ways on different sides of a courtroom, and an online environment that turned all of it into a culture war before the body was even buried. There are no clean answers in this case. There has never been anything clean about it. The verdict is in, and it is final, unless an appellate court says otherwise. The sentence is real, and it is heavy. The grief is real, and it is heavy. The questions are real, and they are heavy. What the verdict room can offer you, what we always try to give you, is an honest accounting of what the evidence shows, what the law says, and what the human reality looks like underneath the headlines. This case is not over because a verdict was read. It is not over because a transfer to state custody happened. It will not be over for years, maybe not for decades. Karmelo Anthony is 19 years old and in a Texas state prison. He will spend at least the next 17+ years there before anyone even reviews whether to let him leave. Austin Metcalf is buried in Frisco, Texas. He will never be 17 again. His brother carries the memory of accepting 2 diplomas at a graduation ceremony that should have been shared. That is the verdict this case delivers, not from a jury, from life itself. There is one more layer to this story that deserves to be said out loud, because it tends to get buried under the legal arguments and the political noise and the social media heat. Both of these young men were 17 years old when this happened. 17. That word carries a weight that the legal process is not really designed to hold. The Texas criminal justice system treated Anthony as an adult because the law required it, and the law is what the law is. But there is a difference between what the law requires and what a community chooses to learn from something like this. A lot has been written and said about the racial dimensions of this case, about the protest outside the stadium, about the online fundraising, about the jury composition, about what various political figures chose to say in the aftermath of the verdict. Very little has been written about what it might mean to actually prevent something like this from happening again. 2 teenagers who had never met, a rain delay, a tent that was not big enough for everyone's pride and fear and stress to coexist safely in for the few minutes it took for everything to go wrong. There were dozens of other students there who watched it happen and carry that memory now. There were coaches and teachers and parents in that stadium who have replayed those moments thousands of times since April 2025. There are high schools all over the country where teenagers carry things in their backpacks that they should not be carrying, and where confrontations happen in hallways and parking lots and under pop-up tents. And most of the time, those confrontations end without anyone dying, but sometimes they do not. What this case demanded of adults everywhere, and what most adults did not give it, was a serious conversation about all of those things simultaneously. Not a conversation that picked one teenager and one family to be the symbol of something larger. A conversation that looked at the whole picture. Austin Metcalf deserved to graduate. He deserved a college career and a future and the chance to look back someday on the track meets of his high school years and laugh about them. He deserved all of that, and he did not get any of it. That is the irreducible center of this story, and it should never be moved from that position, No matter how many other conversations the case generates, Karmelo Anthony deserved the chance to walk across a graduation stage a few weeks after April 2nd, 2025. He had earned it. 2 jobs, team captain, clean record, weeks from the finish line. He does not get that either now. He gets decades in a Texas state prison. That does not mean the jury was wrong. It means that 2 tragedies can exist inside one event, and that acknowledging both of them is not a contradiction. The people in Frisco, Texas, a city that had already been dealing with its own internal tensions around race and community before any of this happened, are living inside the aftermath of something that a verdict and a sentencing and a transfer to state custody have not resolved. The community is still fractured. The school district still has students who were there that day, coaches who were on that field, parents who drove their kids to what should have been an ordinary spring sports event and spent the rest of their day in a completely different kind of shock. That community deserves more than what it got from the national conversation, which mostly used Frisco as a backdrop for arguments that had been happening long before April 2nd, 2025, and will continue long after the Anthony appeal is decided. What the verdict room comes back to, every time, is this: the evidence, not the politics, not the fundraising numbers, not the social media posts from celebrities or politicians who weighed in from a distance. The evidence, the law, and the human beings whose lives are at the center. The evidence in this case was heard by 12 people who sat in that courtroom for days and deliberated for 3 hours. They made a decision under a legal framework that has been constructed over many years by many people, with all of its imperfections and all of its strengths. Whether you agree with the outcome or not, and many people in this country genuinely do not, that is the system that delivered a verdict on June 9th, 2026. Karmelo Anthony is now in that system. He filed an appeal. His lawyers will work through the record. An appellate court will eventually rule on whether the trial was conducted fairly and legally. That process could take another year or more. If the conviction is upheld, Anthony remains where he is. If the conviction is reversed, a new trial begins, with everything that entails for both families all over again. Austin Metcalf is not in any system. He is gone. That is the only thing about this case that is truly, completely, permanently final. If you have been following this case since the beginning, or if this was your first time hearing the full picture, drop your thoughts in the comments below. What do you think the appeal will accomplish? Do you believe 35 years was proportionate? Do you think the Batson challenge has real legal merit? Do you think this case changed anything about how you see the justice system, or how you talk to young people in your life about conflict and consequences? This community always brings thoughtful, grounded perspectives, and we want to hear yours. Subscribe to The Verdict Room if you are not already part of this community. We cover the cases that deserve more than a 30-second update and more than a hot take. We go deep, we stay with the story through every development, and we deliver the verdict that the evidence actually supports. Hit the like button if this breakdown gave you something real to think about. New investigations every single week. Evidence speaks. We deliver the verdict.